case on the docket, Kisnad versus Water, Condominiums. Both sides of this.
Yes, Your Honor.
Yes, Your Honor.
You may proceed.
Thank you, Your Honors. May it please the Court. Michael Korn of Korn & Zeno, along with Jordan Deal, counsel, heavily representing the appellant, Dr. Kisnad. We would ask to reserve 4 minutes for rebuttal. Your Honors, this case involves a rescission action brought by Dr. Kisnad and a declaratory action brought by the appellee, Water's Edge. Basically, the dispute is over a approximately $236,000 deposit, which has been paid for the pre-construction purchase of 2 condominium oceanfront units. As stated forth in the briefs, the major issues which we believe supported rescission and which caused, respectively, the trial court to err was the court's acceptance of parole evidence dealing with what the actual construction specifications of a window treatment on the outside of the balcony, which was described as year-round flexible space. This is a significant issue which we'll talk about in a moment.
Okay, what about the reference in the plans to the product? Because the plans were clearly part of the contract.
Well, yeah, and here are the plans, Your Honor, 320 pages.
I understand that.
A lot of them. Well, let me focus on the plans for a moment. First, the evidence was stated that the plans were never given to Dr. Kisnad prior to his execution of the contract in December.
But the contract specifically said that they are available in the office of the company.
So he had access to them. He could have looked at them.
Well, there was a dispute in the testimony. Dr. Kisnad said, I wanted a copy. And they said, no, we'll get them to you, get them to you. And they ultimately did not get them to him until several months later.
Does all that matter if the contract specifically says they're available for you to review in the office? Well, I mean, I'm not sure that's reasonable, but I'm not sure that's what's in front of us.
Well, it is unreasonable, and here I would respectfully suggest why. The issue about the actual construction of those balconies, this flex space, was of critical importance because it not only dealt with the usability of the space, but it also went to the square footage, which we'll talk about a little bit later. So Your Honor's question was, well, and the trial judge somehow thought that Dr. Kisnad should somehow have been on inquiry notice. Well, in those plans, that 320 plans, there's only 2 pages where the words nano wall are even referred to. And that's all it says is nano wall. At page 1913 of the record, there's a reference, and all it just says is there's a manufacturer, he's called Nana Wall Systems Inc. Nothing, just there it is. And there's a whole bunch of other suppliers that are out there. Then 2 pages later, page 1915 of the record.
It was just that reference without a description?
Absolutely, Your Honor. The description, to the extent you could call it that, is a cryptic description at page 1915 of the record, and this is under section 2.4, which is under the header aluminum framed opening glass wall system. It says the manufacturer is Nana Wall again. It describes the 2 components. Remember, there's a fixed rail, and there's an upper and a lower. There was a gap at the lower. We'll talk about that in a minute. That's not what the material issue is the gaps at the upper. The 8-inch gaps between each of those panels as the glass was deployed, and the gaps between the final.
Show in the brochure?
I'm sorry, Your Honor?
What did the photograph show in the brochure?
The photographs really didn't show much of anything that is useful for that purpose, and the plans show nothing at all as the 8-inch gap. We'll talk about that also.
Okay,
but trying to get back to Your Honor's question.
Yeah, no, look, I think you've answered it.
Okay.
But the plans, as I understand, do not show any gap at all. That there were the plans that were attached to the, not attached, the ones that were available.
They tried to
incorporated do not show any gap at all in the upper window.
That's correct. And the architect Davison admitted as such. And during his testimony, Davison was asked on cross-examination, you know, you made a big deal about the gap, which is called the drainage weep system at the bottom. That's right. Why didn't you, and there's a reference actually to, you can see the gap in a little fraction. Well, how come when you look at the panels and the plans on the upper portion, which is again, the only place you can talk about the 2 separate Nana Wall plans, back to Your Honor's question, which is at 1915, no description of how this thing works. But when Davison was asked during cross-examination, he said, well, wouldn't it have been helpful to at least draw an arrow? There's an 1/8-inch gap here. Well, yeah, that might have been helpful. It didn't do it. And so rescission, remember, is not based on what the seller of the property, the developer, thinks complies with what his obligations are. The obligation is, in fact, or excuse me, the test is, what is an objective purchaser reasonably to understand? And so...
Well, that space was not described as living space.
Well, that's an interesting point, Your Honor, because a lot of...
It wasn't like it was a living room and a dining room. It was outdoor space with this, not gate, but with this structure around it.
It was a balcony. And what was described was that the balconies was really nifty.
Right.
Why?
But it's still outdoor space.
It's outdoor space. But when Dr. Kisnad was, in fact, asked the developer, well, could I make this consider this part of my great room? Sure you can. And more importantly, Your Honor, the measurements of the unit itself included that space as living space. So it's not like, we're taking an unheated garage or a carport and saying, well, that should be somehow...
Can I go back to the reference about animal? I don't want to leave that yet.
And I know I haven't quite finished...
I finished the answer there, so before then we'll get to other stuff. But my understanding of the testimony is that if you went to the Nanowall site today, you would see the specifications of this material. But correct me if I'm wrong, there is no testimony in the record that indicates that at the time this contract was signed, what you could have discovered at the Nanowall site. Is that correct or not? Because it seems to me, as I'm reading it, it says, okay, today, the Nanowall is this. You go to that site and it shows this. But I never saw any testimony tying it up to at the time the contract was signed, and I could be wrong, but at the time the contract was signed, what was available at the Nanowall site.
And Your Honor, A is correct, and B has put the court's finger on really what I think is one of the central flaws which requires reversal, which is that the trial court determined that he could rely upon accessing an internet site to the Nanowall manufacturer and look at what was being published in either, well, the copyright document, if I might. This was entered over objection at Claims 4 in the record. There's a copyright date for 2010 and 2011, both in that. Clearly not December of 2004. The only even tangential testimony might have come from the architect Davidson, who says, well, this is the kind of things that I would rely on. But he never tied up, he never established a predicate that in December or November or October of 2004, the Nanowall system was putting this stuff out, and that, we believe, was the reason why Claim 4 was wrongfully introduced and wrongfully relied on by the court.
And I'm going to throw you a softball here. The Nanowall system in 2010 could be very different from the Nanowall system in 2010.
I would hope that it would be. For one thing, I think the technology would have some level of refinement or other things. And in fact, what was interesting about it, why do I say that? We've been focusing a lot on the 1/8-inch gaps on the upper portion, the above railing portion of this structure. The below railing, that was the weep system, which was originally designed as a 3/8-inch gap to allow...
For the drainage.
That's correct. Well, when Dr. Kisnad did his walkthrough, well, what did we discover? There was an additional 1/4 inch of gap there. So now instead of a 3/8, we're looking at a 5/8-inch gap. Now, I don't know, what the developer thinks is a material adverse alteration, but when you look at the reasonable test, the objective test based on Chapter 718, we would suggest that a reasonable purchaser would find that the lack of gaps, or the lack of disclosure of the 1/8 gap on the upper, the increased gap on the lower, that in and of itself is certainly material and adverse. And why is it so material and adverse? Because it's not waterproof. Now all of a sudden it's water resistant. And what's also interesting, Your Honor, look to the plans. I think just reading them, I found something really intriguing. At page 1912 of these plans, they're talking about water penetration. That's 1.2e. Systems shall have no water penetration when tested in accordance with this, that, and the other. Well,
counsel, let me ask you this. With the Nanowall system and all that, doesn't a court have to look at what's in the document versus what was said to your client versus what wasn't maybe available in 2004, 2006? And the document says you're to have an exclusive folding window terrace system that allows for year-round use of the flex space terrace. Isn't that Is there ambiguity about that we have to look into and go outside of the?
The ambiguity, if there is any, as to that term, year-round use, we believe that the system as designed and as put in these plans does create ambiguity. In other words, if I'm supposed to be sitting out there, even in Florida winter, in January, and there are an eighth, an eighth, an eighth, an eighth all the way around, and we get a wind, all of a sudden that's a much different use of the space.
So you're saying it's ambiguous, we should go beyond the language of the contract?
In that particular instance, because, and again, there was a lot of testimony about what the reasonable expectations of the buyer were, whether it was supposed to be weatherproof versus what Manawal is now claiming to be simply weather resistant. There it is, I believe, ambiguous. Now, what's not ambiguous, and I see my time's about to go.
I may give you more, because I have a question.
Certainly. But I don't want to look like I'm picking and choosing, but on the ambiguity issue, I did want to at least mention the issue about beach access.
Well, I have no.
Okay, no, that's the beach access. You want to go on the Nanawal? I'm going to ask.
I'm not done with Manawal, I'm going to
And I've
ask
got a
about beach
question
access.
about the beach
I want to
access.
get, okay, let me
Thank you.
go to the first question on beach access.
So if I might, if I can just tie it down in 10 seconds, we believe that this.
I'm going to take that away from you. Okay.
The exhibit had no evidentiary credit. It shouldn't have been introduced, shouldn't have relied upon it, and the court relied upon it heavily, and that was what we believe was one of the errors here.
Okay, it seems to me that, you know, you don't like it. Part of the contract is the plans. And the plans had a landscape plan. And that landscape plan does not show a bridge over the dunes. Why aren't we bound, notwithstanding your client's expectations, why aren't we bound by the plans, and why is he bound by the plans as to beach access?
Let me try to address that question briefly, and then we'll talk about the landscaping plan itself. What's intriguing is, in the original contract, it said, because he didn't have the plans and specs at the time, it said you can rely on the prospectus, and you can rely on the sales and marketing materials. Now, what you will find at Joint Exhibit 5, Volume 11, page 2062 of the record, you're going to see one of these site plans. You're going to see several site plans. I think council's got a few for you as well. We'll talk about them on rebuttal, I suspect. When you look at that document at 2062, you're going to see the rendering of the building, you're going to see the ocean, you're going to see the dunes, and you're going to see a line, a shaded, darkened line that's going to run. Where's it going to run? It's going to run between the two dunes that are referred to on the topographical map, which is one of their little boards. So, to your question, what was said? Was there somewhere in the document that said there shall be a beach dune walkover? No, there wasn't. Was it reasonable, however, for the buyer to assume that there was going to be beach access? Yes, there was. It was reasonable.
To be a dune walkover?
Well, either a dune walkover or some basis to access the beach, the actual ocean, the shells, the water, other than taking the, what I called in brief, something somewhat lighthearted, a Rube Goldberg attempt to try to manufacture access, which was to walk out what became known as the gate to nowhere.
Well, let me.
And of course, I'm sorry. Just say, of course, we have to be careful that we're not making a decision in your favor based on Dr. Kisnad's particular sensibilities of what he expected. And I can see why you would expect this grand walkway that you're talking about. But that's not what that contract said. That contract didn't say you will have private access. You will have private beach access.
Beach access.
It just says you will have beach access.
And
And it didn't say you might have to walk a little bit, but you'll have access. It certainly didn't say you'll have private beach access.
That's correct. But it wasn't, Your Honor, to your point.
And of course, he's bound by the words in that contract.
To your point, it wasn't just the buyer's expectations, reasonable or unreasonable. The expert appraiser, Swearinger, who testified, who was very familiar with beachfront property, says when we in our business are talking about beach access, we're not talking about walking down a gate, perhaps trespassing on somebody else's property, walking to an existing public parking lot and an existing walkover. That's not beach access. I mean, I don't live at the beach. If I lived in town, I've got beach access the same way. I would go to that same
Let
lot.
me just have one follow-up question on that. Was there any evidence to the contrary? Was there an expert who testified otherwise? Was there an expert who said, no, beach access really just means this gate's going to be just fine?
The only, well, there was no expert brought on by Water's Edge. There was testimony from its principal, Mr. Buckley, where he just said, there's the gate, that's beach access as far as I'm concerned. What's significant, though, Your Honor, although it wasn't expert testimony, when Dr. Kisnad did the initial pre-closing walkthrough in October of 2006 and saw what was actually going on and confronted Mr. Shiner and Mr. Green, who were the representatives of Water's Edge, they basically acknowledged, yeah, well, we thought we were going to have a walkway over, permitting, whatever reasons we didn't do it.
Well, help me here. You used a term very interesting when you were talking, perhaps walking across someone else's property. And you used that term perhaps. Is it clear from this record whether you actually walked across someone else's property? Because it seems to me you have a lot stronger argument, you know, if you have to trespass into someone else's property that you don't have beach access. And there was testimony, everybody said, well, it looked like it was somebody else's property, it might have been somebody else's property. Where are we on that?
Well, Your Honor, the record first does not reflect actually the length that a person would have to actually travel to go beyond the Water's Edge property across the, you know, this neighboring and get to this thing. And as to your specific question, I don't recall anything specific in the record that said that you are either walking on the neighboring property or trespassing, whether there's an easement or otherwise.
Well, where does that leave us, though? In writing our decision, I mean, the trial court ruled against you. Where does that leave us if the record is unclear?
Well,
as to whether you're going across somebody else's property. When I write, using the term I, but you know, the panel writes its opinion.
yes.
Where are we when we lay out the facts as to whether this was walking across somebody else's property?
I think you would have to honestly say that the record, because you're going to have to remand on the issue of the porch, and because of the Stanwell thing, that you would suggest that there be perhaps additional limited fact-finding as to whether, in fact, there is, in this traversing across to the neighboring walkway to the south, whether in fact you are on an easement, whether you're trespassing, whether you're welcome to use the property.
Bottom line, there's no evidence to suggest that people have to
Now,
trespass on
Your Honor,
somebody's
there are
property.
photographs, and I tried to mention in the brief in a footnote, there were photographs which indicated the path. I couldn't tell you with specificity because there's nobody actually walked in and measured it as the length.
So
And nobody
it's
ever
not-
did it. I'm sorry.
I'm sorry. If the doctor didn't have to trespass on somebody else's property, it sounds like he had access, but not the happy access we wanted.
Well, again, but we go back to the swearing testimony, and I go back to the testimony unrebutted.
So beach access is ambiguous.
Exactly, and well, I wouldn't say it's necessarily.
We have to get extrinsic evidence.
Well, the court, and this was the intriguing thing, the court found it to be ambiguous, and then really created this whole idea of, well, you really get beach access because you go out this gate to nowhere and you can
So
travel.
would you have us write an opinion defining what beach access was?
I think based on what, I think Judge Wolf's comment is a prescient one in the sense that if additional fact-finding is necessary to determine whether that path was in fact an authorized path or whether persons are actually
I
trespassing.
mean, that sounds like the evidence that the party should have developed during the trial.
Ideally, it would be, Your Honor.
And it wasn't.
Sure, I understand.
Okay, even if it's not private access, I mean, I'm playing here, don't take what I say to be where I'm going. If I assume at this point that I'm defining the term at least as reasonable beach access. There was a lot of testimony here concerning that this was up a hill, that it was a loose path. Again, where am I as far as the trial court either making findings or not making findings
Well,
on that? I mean, could I say this is unreasonable beach access? Because I'm going to ask the other side of this, because the undisputed testimony is that this was a loose path, dirt, it was up over a hill. I mean,
You're talking about
it seems like that testimony given, it seems like that's undisputed testimony. I mean, well, if it was speculation as whose property was on it, it seems like undisputed testimony as to the, how good the path was to get to this accident.
no one ever in my review of the record, no one ever made a representation that this was an easy way to go at that time. My time is more than expired, but I'm at the court's pleasure.
I am going to be very liberal with the clock here. It's one good thing about sitting in the center, I get to do that.
Yes, sir.
Keep it going.
And we say,
Any more questions?
If I could ask this, if I just bought that lot, there's no condominium on it, I've got certain literal or riparian rights, and one of those is the right of access. What would that be at common law, for the access right? I would assume that I could go over the dune, because I assume, is the dune private or public property? That's the other question. Common law rights, and where's the property line? Is the property line at the wet beach, or is it up next to the gate?
There was kind of a dispute as far as this record as to where the property sat vis-a-vis the coastal construction setback line.
That went right through the middle of the condo, I think.
Yeah, and in fact, Mr. Buckley testified that because of that, there were some remediation efforts that they had to engage in. But to your question about where the actual property of this condominium project, I believe, and you'll probably see it on their plans, but I think again, it's right at the gate part where their kind of gate to nowhere goes.
Because my question,
But whether it's owned by the condominium or whether it's owned by the people of the state of Florida, the access issue still remains the same. Now, the topographical map, which again, that's one of the things I suspect the other side is going to want to show you, is going to show you a grade of dunes, and you're going to see a dune here up to approximately 19 feet. Another dunes to the south of that. But again, if you look at that brochure that's referred to at page 2062, you're going to see a little path in shaded that shoots the gap between the dunes.
did the doctor have walkover at his condo that he was living in?
He did. Well, it was unclear whether it had walkover. He clearly had direct beach access. I believe it was a walkover. But and that was in fact an important factor because this was not a novice purchase either.
Okay, I'm going to give you an additional 3.5 minutes for rebuttal, which will put you an extra 10 minutes. So if you give the other side an extra 10 minutes.
Thank you. I appreciate the court's indulgence.
I think we're indulging ourselves here.
There are benefits to going last, I guess.
May it please the court, my name is Poppy De Cunto. I'm here with Steve Durant on behalf of the Appalachian Water's Edge Condominium. If we can first address the nanowall issue, so I'll go in the same order that Mr. Korn had. It's very clear when you look at the plans, specifically in reference to the nanowall SL25, and that's exactly what's referenced. Aluminum frame, opening glass wall system, Nana SL25.
What's this from?
This is from the plans, which was stipulated in pretrial stipulation that these were incorporated into the contract.
Okay, but there was testimony, and I'm not great at reading plans.
Right.
But there was testimony that the plans showed no break in the windows
And what they're
above on the upper part.
I believe what they're referring to, Your Honor, was this. There's just a line. There was testimony, however, from Mr. Davison that the reason that there was no showing of a break in there is that the 1/8 inch was too small to reflect on architectural plans, which is why he specifically referenced the exact system that was going to be used on the plans. And
What's the reason for the space, for the gap? Because it has its own.
Yes, it's a folding window system, and because they were trying to get an unobstructed ocean view, they didn't want anything in between the windows.
The one that's folded completely.
Exactly. The window folds completely back, and then when it closes, it's glass
So
on
in order
glass.
for it to fold away, there has to be that gap so it can fold away.
There has to be a gap because you can't have glass against glass. And if they were to put something between the glass, then you wouldn't have an obstructed view anymore.
And was that information available to Dr. Kisnad at the time of the intention contract?
They always planned on using the NanoWall SL25 system. The system was the same, and Mr. Davison, who was the architect, testified that the specifications he reviewed as to the NanoWall SL25 were the same as that's on the internet now. There was no evidence as to whether those plans existed on the internet, but in terms of what the system looked like in 2004 and what it looks like in 2010 or 2011, it's the same.
Okay, but is it reasonable to have somebody that's signing a condominium document to be researching all the specifications for all the projects. I mean, I can see the argument, you know, you're required to look at the plans. But I have some problem here, that if I'm a condominium buyer, that I gotta go look at the technical specifications for all the products that are listed on there.
I think the problem is, it's not a question as whether what Dr. Kisnad's reasonable expectations were. The question is for the court to have decided, was there a material adverse change between what was promised in the contract and what was delivered? They promised the NanoWall SL25 system. They built on the upper top the NanoWall SL25
Yeah, but if I'm buying, I don't know what a
system.
NanoWall S25 system is. I mean, I figure, you know, that's some windows. It's a Pella, you know, whatever. And if it doesn't show a break, why should I be concerned? Shouldn't I be able to rely on what's listed in the plans?
No, Your Honor.
Than having to go look at each individual specification. That's part of my hassle here, my problem. You got to get around a little bit.
Well, I think it's interesting that Dr. Kisnad's arguing he never saw the plans. So for him to first say, well, the plans don't show a break, and therefore they should be stuck.
But the plans are part of the contract.
The plan is part of the contract, but when you're talking about what does Dr. Kisnad and what are his reasonable expectations, he can't say, I had a reasonable expectation from reviewing the plans, because he claims he never got to see the plans. However, to your point as to whether a buyer has to, what steps they have to take to inform themselves of the contract, we cited in our brief and to the trial court on Condominiums versus Advanced Auto Insurance, that stands for the proposition that Dr. Kisnad had a duty to learn and know the contents of the contract and to make the necessary inquiries about its ramifications before signing it. He's bound to its contents. So if he had questions about what that system was and what it meant, it's clear under the law cited in our answer brief that it was upon him to determine what is that system. It's also clear that this system was never going to be weatherproof, and that's exactly what the court found.
It almost seems like, from an engineering standpoint, if these windows are going to fold back, it can't be airtight.
Exactly, Your Honor. And it was very clear from the lower plans that there was always
Because it's
going to
not a wall, it's a fold-back system.
Exactly. It was a flex space terrace designed for year-round use. It had an outside grill outside. It was clear that this was just additional space. And in terms of the living area, it specifically references, when it talks about the calculation of the square footages, that the living area includes the flex space balcony.
Now, with the spaces, the gaps, render the balcony unusable for certain times of the year? Would it render the balcony uncomfortable certain times of the year?
No, Your Honor. It's clear that it was a weather-resistant system. The gaps at the top are 1/8 inch, and the gaps at the bottom were going to be a 3/8 inch.
And was it always called weather-resistant, or was it some point was it called weather-proof?
It wasn't described as either in the contract. In the contract, all it says is that it's going to be a flex space balcony designed for year-round use.
Okay.
It doesn't make any representation that the space is going to be weatherproof. The only testimony that the space was supposed to be weatherproof was from Dr. Kisnad's expert, Mr. Malley. Mr. Malley also...
Well, I mean, they're kind of making the argument, if I understand it correctly, that on the square footage, because it's included in the square footage, they had a right to rely on it being more than just weather resistant.
And I make the exact opposite point, because when it shows, when you look in the sales materials and everything else, it says the living area includes the flex space balcony. And then the definition in the condominium says the living area is the heated and air-conditioned space plus the flex space balcony. So if you were going
So they knew
to...
it wasn't just enough room.
Exactly. If it was just part of the regular weatherproof space, there'd be no reason to have that little asterisk and say, we don't want you to be confused, we are including this balcony in the living area. And the reason they needed to provide that asterisk is because it wasn't going to be weatherproof space. And they had never said anywhere that it was going to be weatherproof space.
In fact, you really couldn't put a grill inside.
Exactly. And it refers to specifically that it's a summer kitchen with a gas grill.
So when they define square footage as the livable square footage plus the terrace?
Yes, if you look specifically in the...
But then that wouldn't be, well, I guess it's concerning me because if I'm buying something based on square footage, it's typically the heated and air space. that is in this, but that's not what your client did.
No, that's not what they did. And I agree with you that if they had just said living area or habitable area, that would normally only include the heated and air-conditioned space. However, because they provided a specific definition of what their measurement was.
So if it said include garage, the square footage would be another 700 square feet wherever the garage is.
Exactly, and that's why
But
you
isn't
have
that kind of confusing to consumers?
Well, I think that's why you have to look to the language of the contract itself.
There's no common measure of air-conditioned, heated square footage, livable space for a square footage disclosure requirement.
No, Your Honor, I'm not aware of any, and I believe that's exactly why in the condominium documents themselves, they define the interior floor space, and they say, look to Article 4, and it tells you, when we're giving you the square footage of the interior floor space, or what we also sometimes call living area, it's the heated and air-conditioned space, plus the walls, plus the flex space balcony, which tells you that's a different space from regular heated and air-conditioned space. Mr. Korn also made the point that the additional 1/8 inch of a gap, or a 1/4 inch of a gap at the bottom was a material adverse change. It was clear from the testimony from Mr. Davis and the architect that that slight change was made to actually increase drainage, so that if water did get in the balcony, it could drain out. I don't believe that an additional 1/4 inch to actually allow the balcony to function better.
To benefit.
Exactly, exactly. So it can't be a material adverse.
Benefits in the eye of the beholder.
Well, if you want to be able to use.
You know, if you're varying from the plans, you know, just because you say, we think it's going to help people, and they may not think it's going to be a great help to them. You see what I'm saying? I mean, you can't willy-nilly change all the plans and not give people an opportunity to back out just because you say it's better for them.
I agree with you, but that's why it's also an objective buyer standard, which is would an objective buyer think that it's a material adverse change to increase slightly by 1/4 of an inch a gap that was already going to be there. It was going to be a 3/8 inch gap. It increased it by 1/4 just to allow for better drainage. And I think that if an objective buyer would appreciate that the balcony is going to be functioning better in terms of their ability to use it as a year-round space, because if rain got in, it would be able to drain out easier.
When would the 15 days run under the statute?
It would run from the date that they gave him notice as to the changes. And I believe that they...
But there were no notice of changes as to the window system.
There was no notice of changes as to the window system.
So when was it? Is it 15 days from the closing in 2006, or is it?
I'm not sure. I don't know in this factual situation.
Because, okay, if I'm a purchaser and I signed the purchase contract in 2004, and construction goes on for 2 years, and then I just show up at the closing, or for the first time I see something that I think is a material change that I didn't agree to. I assume it's at that point, 15-day window is triggered.
It may be.
Even if I've done nothing, I've not looked at anything online, I've been totally out of the process.
It may be that that's in the 15 days run. Nobody ever challenged Dr. Kisnad's timing of when he made these objections. The Water's Edge court has always been, there was no change. So there was no change from what was promised to be delivered and what was actually delivered.
So no need to notice anything.
Exactly. And when he raises this issue and they change, they didn't say, well, you know, more than 15 days has expired. They just said there is no change to discuss. Same thing.
Okay.
No, I don't want.
I was going to switch gears to the beginning, but or to the.
Yeah, I was going to go there too. You can go first.
Isn't it, as a practical matter, owners of beachfront property, if they don't have a walkover, isn't there typically a path where people have walked through the dune? So that what you have here is a lot that fronts on the ocean. You have a restriction about the dune usage. You don't have a walkover. So people from that property either have to have over time put a little pathway through the dune that they go over, or they walk onto the state side of the line, but not into the dune, and walk parallel to the beach to the next access point. Isn't that typically how the two ways, or I guess they could go inland and down to the end of the street and then come out?
Well, and the second way that you described is exactly what there is in this specific unit. You walk out of the gate, you walk on the public property part of the beach, which is the westward side of the dune, and then you cross over public access.
Eastwards.
Okay.
Eastward side of the line with the west side of the dune.
Correct, correct. And the beach access is said in one brochure. On one brochure it says beach access.
Okay, before you go on.
Yes, sir.
Do we have to say, you have the word reasonable in front of beach access here? you know, if you're providing beach access, doesn't it have to be reasonable?
I think you have to put a reasonable construction on the contract in terms of what did the contract mean by beach access. And I think when you look at the contract as a whole, it's clear what it meant by beach access. It used the two words beach access, and then over and over again it provides a picture of
What
what
if
it
the beach
means.
access was a mile down, and there was a path going, you know, let's assume this is not walking across somebody else's property,
Right.
but the public access was a mile down, you have to walk a mile down on the west side of the dune, would that be beach access?
I think that if it shows in the contract that you're giving a gate there, the fact that the longer you have to get to the public access, at some point, I agree with you, it's ridiculous. And a mile may be at that point. In this instance, the public access is only about 25 feet away. It's not, we're not talking about a mile down. And in terms of the testimony
Is the
about
record
whether,
clear that it's 25 feet?
I'm not sure that anybody actually went out and measured, but I believe that Mr. Buckley and Mr. Davison provided some,
That'd be a pretty narrow lot, because I understood there's a lot next door.
there is,
And it's just 25-foot wide lot?
it's not a wide lot. I'm making an estimate of the 25 feet. I'm not representing to you that somebody testified it's 25 feet, but it is one lot over. And then there's the public access.
Okay, now, there is testimony in this record, this is an unstable path, that it has some height to it. Where are we as far as that? Because that's undisputed testimony.
I think we're back to looking at what the contract showed was going to be delivered. When we talked about,
Forget the contract for a second.
okay,
If this was a, I'm going to be absurd again, a mile down, if this was a 30-foot high steep slope that was very dangerous to walk up and down, would that be beach access?
I know you want me to forget the contract, but I think again it goes to what the contract showed. The contract in this case shows very clearly on the landscape plan that there are going to be dunes reconstituted in front of there that are 20 feet high. So it's showing you what you are going to be delivered, and that is exactly what was delivered. They said in terms of the beach access, they built it in exactly the same accordance as what was shown on the plans.
And what was shown on the plan? The gate was shown as the beach access.
Yes, Your Honor. Let me start first with the front page of the plans.
And what about the shadow path that Mr. Horn was talking about?
I honestly don't know what he's referring to. So I
Well,
would
he'll get to speak for
He can
himself.
speak for himself.
Yeah, you gave him all that extra time.
I don't know in the record what he's talking about. This is the
But as far as
plan.
you're concerned, that gate
Yes,
is the beach access.
yes, and it's clear, and Mr. Davison testified that if there was going to be any other access, they would have to show it on the site plan. This is the site plan. This is the gate. This is the property line. So when they said we don't know where the property line is, the property line is outside of the gate. Then it extends over to public property, and there's one long line. But again, all it's showing is a gate. The landscaping plan.
But okay, I see that I need to get to the beach, assuming I'm not going to walk through the dune, is I walk parallel on my property, the condo's property, up until I get to the neighboring property, and I have to do what?
This is actually a public easement, but so you walk
Is
through there.
that
and then-
clear from the record?
I believe so. There was a survey admitted into the record, and I cross-examined Mr. Swearingen, their appraiser expert, about it, and about whether or not they were actually crossing into somebody else's property or whether that was public property.
So your position is he's got the beach access. He just has to walk.
Exactly, and that nothing was ever shown other than what he was going to get. And the landscaping plans are significant because they say, well, when you look at this, it doesn't show you a high dune. And that's because at the time this picture was taken, there was no dune there. However, the landscaping plans show exactly what the dunes are going to be after you are done with the
And they're showing the precise topography of them.
yes, if you can, I'll let your honors look at this closely, but this shows 19 feet.
Okay.
So it shows you're going to have 19 feet here, and here is the gate.
I was just going to ask, where on that is the
The
gate?
gate's there. I kept the highlighting as to what it was at trial, so I didn't want to circle the gate because it hadn't been circled at trial. And these are the landscaping plans that show, again, the gate, and they show they're going to be planting all the seals. And again, if there was going to be a path or even little steps put down to allow you to walk over the dune, that would have been shown on the landscaping plan. It's not
So
there.
the government property line between private property and public property is right near the gate.
Yes, sir.
So that must be because over time there's been avulsion or some sort of change the beach, because typically the property line is where the mean high water line is, where the wet sand and the dry sand separate.
I believe the public entity actually keeps an easement, so they can come on, and I don't know what the public purpose is of it, but they keep an easement right there that's at the property line. So I'm not.
So actually stepping through the gate onto the public property is tantamount to stepping onto the wet sand.
That's what we would argue, yes. You've now accessed the dune, which is the sand, which is the beach. And that's all that was promised. The trial court made a specific finding that Dr. Kisnad...
I only knew that because I had done a little work in this area before, but I'm not sure consumers would know that.
Well, but that's why, again, it's not a subjective purchasers. It's, did we represent in the contract what we were going to deliver, and did we deliver that? Exactly what the contract says is going to be delivered was what was constructed and what was delivered to Dr. Kisnad. I'd like to speak a little bit about how the living area was calculated and the parametrical versus the living area. Again, there was no change in what was promised to be the living area that was going to be delivered and what was actually delivered. In the briefs, I noticed it was a little confusing because we referenced the original square footages of 2308 and 2457.
What was the need for the method to be changed?
The Florida legislature actually changed how you were allowed to calculate condominium association dues. And they said for purposes of condominium association dues, you can't include the walls. So before, as the definition is I mentioned to you before in the condominium documents, it defined interior floor space to include the walls and the flex space balcony and all those other things. The parametrical measurement is also clear in the Second Amendment prospectus, says it's the heated air conditioned space, the flex space balcony, and the interior boundary wall, so it's not including the wall anymore. Both measurements were still provided in the Second Amendment prospectus. Nothing was changed. They still define the interior floor space and the living area as the same number that Dr. Kisnad had already agreed to. And then they provide an additional parametrical measurement saying, and this is what we're going to base your condominium association dues on. But the actual square footage that was built was the same in the plans as what was promised. One area I think of confusion was that originally the square footage was 2308 and 2457 because he was buying 2 units. There was a slight reduction in that square footage, and Dr. Kisnad agreed to that. So there's an amended prospectus, and it was, excuse me, Plans Exhibit 1, where Dr. Kisnad agreed to a slight reduction. So when you look at the original sizes of the prospectus and the second amended sizes, the reason that there's a difference is because of this change that Dr. Kisnad did agree to. But the living area that was promised to be built was the same that they delivered, and there was undisputed testimony from Mr. Buckley and Mr. Davidson that they built the unit exactly as promised.
Bear with me on this riparian rights issue. If that property line between public and private property is as you state, and the government has said you cannot traverse the dunes out in front of your property, why hasn't that action taken away access government lines? Why isn't that taking? Or has this property owner already acceded to the fact that they don't have direct access to the water? Because it's direct access to the water, not the beach. That's the riparian right. Has this property owner already basically acceded to the governmental action and said, I'm just going to accept this situation as it is?
They had, the representative from the developer, Mr. Buckley, testified that they looked into whether they would be able to traverse the dunes or build something over the dunes well before they developed any of their plans. They were told it was absolutely impossible, it was never going to happen, and that's why...
For what reason? Too expensive, or just regulatory in terms of regulations? It looks like there's a walk over every block, every street, with a few exceptions.
I'm not sure as to why the government wasn't allowing them to build a walkway. I just know that Mr. Buckley testified they were told it was not going to be able to be built. And that's why in none of the renderings did it show a walkway. Obviously, if they were going to be able to have that, or if they hoped to have that, that was something that they would have put in their promotional literature and also in the plans. And Mr. Davison, the architect, testified, I absolutely would have included that in the plans had we anticipated being able to provide that. But it was never expected that we would be able to provide that. And I would like to note that Mr. Davison also testified, and the plans show that they're dated October 2004. The contract with Dr. Kisnad wasn't signed until December of 2004. So it was clear that the plans were done. There was testimony from Mr. Buckley that the plans were available in the office for review. And Dr. Kisnad couldn't have looked at the plans had he wanted to, and he signed a contract that he acknowledged that he had the plans, or that the plans were in the sales office and he could review them. Unless you guys have any other questions, then my presentation will be much shorter than this report.
Us guys do not.
I'm sorry for the immorality of it.
You didn't read your topic.
Mr. Corn, I just went back and read the order. And while there are no specific findings as to the reasonableness of each access, don't we have to assume that the trial court did find that each access was reasonable, and any deficiencies in the record as to how far it was, as to whether it was on somebody else's property, whether how high, it was, don't we have to, it's your responsibility as appellant to demonstrate a reversible error. So don't we have to kind of take that all and read it against you?
Here's why I believe that would not necessarily be the case, because the outcome, if you will, that the trial judge came up with was not one that was really advocated by anybody at trial. It was a comment that the trial judge made, and it was the first time that anybody talked about the inability or the ability to traverse the dunes. To Judge Bakar's question about the informal footpaths which are dotting every Florida beach, it was this judge who made a determination outside of the request of the party to say, well, that's good enough, that's the access. So with respect, Your Honor, I don't believe that has to be given any kind of great discretionary weight.
But in doing that, wasn't he describing why the beach access was available?
Well, I suppose you could say that he was, but was it reasonable? Counsel said that, and I know she didn't mean that it was necessary 25 feet. I know there's no record of that. The reason is, if you go back to the record and look at Joint Exhibits 11 for photographs, specifically 15 to 21, you'll see the length. It's not 25 feet. It's not a mile, but it's not 25 feet either. So I think that's an important thing.
And what about the testimony that she referred to in the survey that was an easement that people were walking across, that was not walking across somebody else's property?
If that's the case, it still deals with the issue of the reasonableness of that access. I mean, I think to Your Honor's question earlier, the idea of it's trespass is almost verboten as opposed to.
No, certainly if there was.
I'm sorry?
Yeah, but we don't have that as trespass.
I understand that. I'm not sure where I am on time, but I did want to just
You're
address.
about done. I'm going to give you 30 seconds.
Thank you. Parametric measurements is a red herring here. It's not the same amount. Dr. Kisnad specifically testified he was pricing units based on square footage. And remember the brochure they said you can rely on, which is at R11, 2057 through 2074. They describe each of the various units. What do they describe? Seashell, which is one of the units he bought. Total living area. It's not, it's different. This is why it distinguishes from that Paramount Lake Yola case that's in our briefs, in which the court, I think, mistakenly relied on. Same with the other unit that he bought, the Starfish. Total living area. It was reduced because of the change in statute, but it doesn't affect the fact that that was the living area. They say, well, it never changed. You got the same living area you were going to get. They told him he was going to get different amount of space. That was the material difference. That's why rescission was appropriate. My time has way expired. Thank you, Your Honor, for your purposes.
Thank you. There being no further cases in front of the court today, the court will stand in recess.